Sorry about that. Good afternoon. My name is Emily Bergeron. I'm an associate professor at the University of Kentucky and vice chair of the Environmental Justice Committee from the section of Civil Rights and Social Justice. In partnership with the ABA Commission on Disability Rights, we're thrilled to be presenting this webinar on rights of persons with disabilities to access to public natural resources. This panel is one of many in a series of rapid response webinars. We're always planning additional programming on a variety of issues. So please visit americanbar.org/CRSJ for updates on these programs. During today's program, we encourage you to ask questions of our panelists through the Q&A and not the chat function. If you don't see the controls, please ensure that your screen is not idle. As today's moderator, I will be monitoring the Q&A and we will do our best to address your questions, time permitting. We will also be sharing a recording of this program with everyone who is registered so that you can share it widely with your networks. Being in nature has real quantifiable benefits. Unfortunately, access to nature is not equitable across populations, even though protecting and restoring access to nature among those of all ages, social groups, and abilities helps alleviate some of the most significant problems in public health today. In today's webinar, our esteemed panel will discuss the issues surrounding the rights of persons with disabilities to access public natural resources, speaking to the meaning of access, best practices, existing law and policy, and tensions between various stakeholders. They'll wrap up with discussion of future directions from their professional perspectives. And now I'm going to turn it over to our speakers who will introduce themselves, starting with Jeremy.
Good afternoon or good morning, depending on where you are. My name is Jeremy Buzzell, and I am the manager of what we call the Park Accessibility for Visitors and Employees program at the National Park Service. I am a white male with short brown hair, wearing dark glasses, and wearing a black National Park Service logo polo shirt.
Hi, this is Stuart Seaborn. I figured I'd go next. I'm Stuart Seaborn of Disability Rights Advocates. We are a nonprofit nationwide law firm, disability rights law firm. We specialize in systemic litigation, often class action litigation, on behalf of people of all types of disabilities. We're a cross-disability organization. We are here because we've had multiple long-term projects and pieces of litigation involving park systems throughout the country. Hope to be able to talk about a couple of them, one involving the state parks in California, another involving the National Park System and the Golden Gate National Recreation Area. I am a white male with gray hair and a grayish beard, wearing a blazer and a white lined dress shirt. My pronouns are he, him. I'm very excited to talk to all of you.
Kristine? Or Reese?
Sure, I can do that. Hello, everyone. My name is Riss Leitzke, and I work with Wilderness Inquiry for about 2 years now. My position is running the
Affinity.
Thank you, Affinity and career extended program, evaluating interpreters, and that recently changed. It has not formally changed the name yet. It's a pretty long one, but I have a mini ponytail. I've got round glasses with short hair, and I'm wearing a dark blue jacket with the logo Wilderness Inquiry on it. And my pronouns are they, them. And I'm extremely excited to be here to discuss with you guys and expose and educate. So I'm very excited.
All right. Hello, everyone. My name is Kristine Perry. I use she, her pronouns. I'm a staff attorney at the Environmental Law Institute in Washington, D.C. I'm an international human rights and environmental lawyer with lived experience with disabilities. So I'm really excited to explore this topic with you and ready for the conversation.
This is Riz. I did forget, I did want to add, I'm sorry, I am deaf-blind as well. So I have a limited visual area. And I use American Sign Language to communicate.
And I apologize. I am a white woman with medium length wavy brown hair. I have gold hoop earrings on and a black dress with a gold necklace.
Thank you everyone for your introductions. And to clarify, I'm also a white woman with dark brown hair and a blue polka dot button-down shirt. If we could start our discussion, I would love for us to start with an explanation of access. So in the context of nature, what does accessibility mean? And this might have different parameters based on what we mean by nature, as in out just green space, as different to exploring the wilderness.
I can jump in to start. I think I'm going to start more with accessibility under the Convention of the Rights of Persons with Disabilities. During this program, I will be sharing more of an international perspective. That's where my work is focused. I'm going to refer to it as the convention or the CRPD, so I don't have to say the whole name every time. But accessibility is under Article 9 of the convention, and it enables persons with disabilities to live independently and participate fully in all aspects of life. So that includes recreation, leisure, sports, things of that nature. And this accessibility is on an equal basis with others, including persons without disabilities. So that's kind of how I start to frame this conversation. I know the other panelists can dive more into what that means for them and their work.
So this is Jeremy from the National Park Service. I'm sorry, were you done, Kristine? Okay. So I can tell you about how, from a Park Service perspective, we look at equal access to the outdoors. And I will start by saying that normally when we have this conversation, the first thing that people do is they associate this with hiking and people who use mobility devices. And that's sort of the go-to when they talk about access to the outdoors. We are looking at access to the outdoors to not only be access to trails and hiking, but that is beaches and boating and fishing and bird watching. In many cases for us, it may be as simple as having an overlook where there's a vista or going and seeing a waterfall. So it's a very, very broad-based definition of what we talk about when we talk about access to outdoor recreation, access to nature, et cetera. And then I would say what we do is we have to ask ourselves in the Park Service the question, why is someone going here? Why is someone going to this waterfall? Why is someone taking this hike? Why is someone going to look at this vista? And that's our fundamental question, because we are not able to provide equal access if we can't provide access to what we call the aha moment, right? It's what everyone came here for, is to see the beauty of the Grand Canyon, to hear the roar of the waterfall, or whatever that may be. So we have to first say, why are people coming here to have this experience? And then, well, what would be the barriers to having that experience if you have a mobility disability, if you have a hearing disability, if you have a vision disability, if you have an intellectual disability. Unfortunately, the answer is not as simple because not everyone comes there for the same thing. So we're going to have to start thinking about like, well, am I coming down this trail for the exercise, or am I coming down this trail because I want to learn about the flora and fauna? Is it some version of both? So we have to look at that sort of the why holistically in terms of making sure, well, not only do I have to figure out what is the experience for me as a person with a mobility disability, but if I'm going down that trail and there are signs and waysides that are talking about the flora and fauna, how are we making that part of this experience accessible? Because the walk might be accessible to a person who can't see, but that information may not be accessible to a person who can't see. Whereas the walk might not be as accessible to a person using a mobility device, but they could read the information. So trying to think about how we are threading that needle in that experience. And then I would also say that once we have gone through and said, what is the experience? What are the barriers to that experience based on intellectual disability, vision disability, hearing disability, mobility disability? How do we overcome those barriers while also simultaneously preserving the resource? Because many people are coming there because they want to have that natural experience. They don't necessarily want it to be paved over or altered or changed in significant ways, because they want to have the same experience everyone else has. So we're really looking at that, and then looking in addition at what is the support infrastructure that makes this possible? What is happening at the trailhead in terms of parking, in terms of bathrooms, in terms of trail information? What kind of supportive information was available to help you with your decision making on our website before you even got there? So there's this whole piece that has to do with it's good and well that we maybe have installed an accessible dock somewhere so that a person can launch a kayak from an accessible dock, but they may not be meaningful if the bathroom near it is not accessible, if the picnic area at it is not accessible, if the campground that is across the street from it or down the road from it is not accessible. There's a whole thinking about what is the infrastructure required to support that accessible experience so that you can even have that aha moment that we call it.
So this is Stuart at Disability Rights Advocates, just to follow up on that. And it's actually remarkable. So we do advocacy under US law. And Kristine, I'd love to hear more about the international scope and what is done and what can be done. But I wanted to focus on a word Jeremy used in terms of the experience, because we do a lot of work under the program accessibility requirements of the Americans with Disabilities Act and Section 504 of the Rehabilitation Act, which applies to federal entities or entities receiving federal funds. And for existing programs and facilities, so facilities that aren't being altered or newly constructed, you really have to provide access to the program services and facilities of those of your park systems, whether it's state parks, national parks, municipal parks, or regional parks. But for us as advocates, it's very hard to kind of get a sense of what the benefits of those programs are for people with disabilities. And we've kind of come up, and I think, Jeremy, this may have resulted from our work with the National Park System in terms of the terminology around our case involving the Golden Gate National Recreation Area. But in the office and among advocates, we use the term experiences. So we want to make sure that the experiences offered to the public without disabilities in all aspects, whether it's making a reservation, whether it's the bathroom, if it's a series of trails, there's a readily accessible when viewed in its entirety requirement under the program access regulations. That means not every trail, unless it's newly constructed or altered, has to be made accessible. So then we have to look at what is the experience offered at those trails. And one of the things in our state parks case, but also the case involving the National Park System, Jeremy's organization. It looked at, so there are trails that provide beach access. So we want to make sure at least the beach access trail or experience is available to people with disabilities. And then things like guides and explanations, how the experience is conveyed in terms of information, things like tactile models. So, you know, the experience of whether it's listening to, seeing, absorbing information, how is that experience made available to the public with disabilities? And it is actually woven nicely into the program accessibility requirements. I actually think there is a kind of tight bond between these requirements that apply to existing facilities and programs and services under the Americans with Disabilities Act and Section 504, and the idea of kind of going through your system and assessing what the experiences are. And it probably means, you know, polling the public, because I agree with Jeremy that they're you know, the attorneys in the room, at least from my perspective, we're often the least creative and the most narrowly focused in the bunch. And so it actually does mean doing some outreach to really determine what, you know, what is, you know, why are people going to that site? What are they doing there? What are they absorbing? What, you know, what is the benefit to them, and what are those experiences? So that's how we look at least from a legal perspective in terms of what programs, services, et cetera, should be made accessible. We fully recognize as advocates, we'd love to have a requirement that everything be made accessible to everybody in terms of all facilities. That is for existing facilities, that is not the law, and I don't know if it ever will be. But then we kind of have to break it down to look at what those experiences are and how to make those experiences accessible to people with disabilities. And just to follow up on the question, I like the kind of description of, and this is by no means an exhaustive description, but in our state parks litigation, working with the state park system, they've essentially come up with a range of programs. And this is not an exhaustive list. And I would encourage folks to look at experiences, but the things that they cover include everything from like bicycling, boating, any kind of exhibit or interpretive program, camping, fishing, hiking, horseback riding, our youth participation programs like junior lifeguards and rangers, even things like off-highway vehicle use, including, you know, getting in and out for accessible egress and ingress to vehicles, picnicking, visitor information, water access. So the list goes on. But I encourage folks, as Jeremy said, don't think of it as just hiking and access to, you know, making sure the trail is accessible. But there's a broad range. And the question was, what is nature? And I hadn't thought of it out in terms of those terms. But we definitely look at what experiences are available at park systems, and how do people get to those experiences, and how do they actually enjoy and benefit from those experiences. So I wanted to mention that before. We'll certainly talk about some of the more kind of legally specific pieces of what to do in some of the debates that have arisen. I think Jeremy raised an interesting question about how to balance the need to preserve these experiences with the need for access, and happy to talk about that later as well.
So,
hi. Really, this is Ruth speaking. I want to agree that, you know, with everything that's been said, to make things accessible means that you also, you know, accessibility is a broad word. We need communication access and physical accessibility, as well as emotional and mental ability and sensory accessibility as well, which means that it is a very broad range of accessibility needs. And once we connect to those nature and wilderness areas, even how you explain those can be a dry, limited experience. You know, I mean, rather the experience might have different climates, whether it's a dry desert area or a wet forested area. And wilderness itself is limited. And what we can see from it, and what other people with disabilities even see the word as meaning, that expression is limited because there hasn't been access to it, or the ability to connect with it or touch it and be comfortable out in it. And you know, and there is no adaptive equipment for many people. So they don't have a broad view of what wilderness even means, even though they may have the curiosity. There are different adaptive equipments available for people with wheelchairs, as well as people with visual and low visual needs. Deaf, blind, other needs are available. There are so many ways that people can have access to those experiences, but maybe they don't have enough maybe the income is not high enough for them to have those experiences. Maybe they aren't able to afford to go out into those areas. And there are many, many reasons people experience barriers, but the experience of wilderness has to be in their way. And it needs to exist in equality, which doesn't mean a low state of equality. It means an equal and different experience depending on what they're doing, that they enjoy themselves and they feel an experience of personal growth and exploration of what that means to people and nature in all of those settings. So, nature therapy itself is critical to everyone.
If I can jump in now, there is something I would like to use that as a segue for, because that certainly resonates a lot with our experience we're having in the Park Service now, which is we have always viewed for a long, long time that accessibility in these environments meant we are changing something. We are making something flatter. We are changing the surface type of something. We're making something wider. And that was the idea of let's call it an accessible hiking experience was created by changing the environment. We are now learning that based on technology, we also have to think about what we call this adaptive hiking or adaptive fishing or adaptive boating, which is we have not changed the environment. What there is some piece of equipment that can overcome the existing barriers. Furthermore, it's us acknowledging even when something is accessible, that's not accessible to everyone. There are plenty of things that are accessible that are not accessible to a lot of people. There are plenty of things that we would say are not accessible that are accessible to a lot of people. So we have to change our focus to how do we provide the kind of information that allows you to make your own decision about whether or not that is accessible with the kind of equipment and the kind of ability you have. That's number one. And then also, Riss, to your point, some of this equipment is very expensive and is very hard to transport. So for us to provide equal access, we've got to figure out how people could get that equipment perhaps locally or in some other way. So we're establishing, when we can, partnerships with nearby organizations that have pieces of adaptive equipment to make people aware that, hey, near this park, we have this place that will let you have this particular kind of wheelchair, or on loan so that you can experience this, and trying to make the connection that says, if you are able to get this piece of equipment from this partner that we know of, we can give you enough information about our trails to help you make decisions about where to use that equipment.
This is Kristine. I'd like to add a little more to this conversation. I really appreciated these interventions, and I think framing disability not as a homogeneous group is so important, that even persons with the same disability might have different support needs, that we are not all the same. We all need different things. And that goes to also our intersecting identities. I'm not only a disabled woman. I have other identities, and so does everyone else that has a disability. And some of those identities experience more discrimination than others, which also create barriers to a safe, enjoyable environmental experience. So it's not only looking at the disability aspect or component of a person, but how all of their identities intersect to give them that safe, enjoyable, and equal access to these spaces.
Yes, I agree. This is Rose speaking. Also, really, we are so highly individual and we have different experiences and different adaptive needs. I agree with that. And for an example, I'm a deaf person. I am fully deaf. I use sign language, but I'm not the same as everyone else. Which means that my needs are not exactly the same. Some people use speech, some people use SimCom, speech and talking at the same time. Maybe some people have access to different languages or don't learn how to have the same language access. But you have to be creative in how you adapt to each individual person and how they use what they need to be comfortable and accessible, maybe, and the pace of their journey.
So this is Stuart, and I'm again bringing the kind of U.S. legal advocate perspective to this, but I did want to focus on the idea that something that may be deemed accessible may not meet the accessibility needs of all, and that there really is an individualized experience, and there should be an individualized analysis. So in addition to the program accessibility requirements and then the more kind of stringent architectural accessibility requirements, when somebody does at a park system alters a facility or newly constructs a facility, there's still a reasonable modification requirement. And some people think of that as a reasonable accommodation. The employment context uses the term reasonable accommodation, and it's almost interchangeable in terms of the concepts when it comes to the built environment and program services and facilities of park systems, and even something that can be designed pursuant to the standards or designed in a way that is, facially, it doesn't discriminate against anybody. There still is an obligation to look at an individualized need, as Riz, Jeremy, and Kristine were mentioning. Disability impacts people in different ways, and assess, can something be done? Can something be done without destroying the kind of the historical integrity or the experience for all? Can something be done to assess how do we accommodate, what do we have to modify to accommodate the needs of that person? There still are defenses available, so it's it's not an accommodation in a certain way 100% of the time. The park system doesn't have to do anything that would fundamentally alter the programs, and this comes up quite a bit in the context of preservation for us. And there are no easy answers, but I also think that there sometimes is a lack of creativity, as folks have already mentioned, in terms of how to preserve environments. And one of the benefits in terms of the reasonable modification analysis is that the courts have interpreted the ADA and Section 504 in terms of the level of access required and the kinds of things that can be done to evolve with technology and the evolution of awareness of needs, but also the evolution of technology. And so things aren't static in that sense. And when park systems are looking at what their existing facilities are, what their programs are, it certainly helps to incorporate the existing standards, because those are the standards of the law, but also, again, to kind of connect with communities and to do outreach to see what they need to be anticipating in terms of possible accommodations or modifications, and to make sure that their policies are fluid enough to ensure that it happens in a way that people can actually access those services, because it is very individualized, and there is, the law is not, it's not ideal in many ways, but it does allow for that flexibility for an individualized analysis, even where that something is deemed accessible under the standards.
So sort of building on that, we have a question from one of the participants, looking at how the individualized nature of accessibility. A question was asked if you could share some ways how experiences are measured or supported in evidence. So what are some evidence-based or assessment strategies for determining accessibility? And I think that flows well into what the legal framework for access would be generally.
I can start by offering some examples. This is Stuart, but I certainly welcome others to do so. One thing that we did, and this now dates back, 10 or 15 years, but was very helpful, is work with accessible disability access programs in sports and adaptive equipment and the environment, and actually go out with groups to various park activities, park facilities, because we had no idea. And in fact, some of the things that we had planned to include as either compliance with settlement agreements or things we were going to recommend to folks dealing with compliance on the park side, we had to modify after working with individuals. And I'm in the San Francisco Bay Area. There's a Bay Area outdoor recreation program, BORP, that does a lot of access and adaptive technology, accessible equipment. And there are several groups. I think it's worth doing some homework to actually go out on site. And that on site also includes making, how do folks make reservations? What access is made available to information. So, for example, information about accessible facilities and features on the website and so on, or in accessible formats. But in terms of the evidence-based, for us, it's often been, in particular, because this is such an individualized analysis. And I think that the standards have improved over time quite a bit. And I like the fact that even, some state parks in California have actually issued their own standards, kind of post-dating the litigation. I love what the National Park System is doing in terms of kind of established models and changing those models with evolution. But none of that stuff can keep up all the time with needs and experiences. And it really, for us, has been working with community groups who, both have existing programs to provide their membership with access, but also community groups that may not have done so, and to kind of do a needs assessment in terms of what their needs are. We've often gone to places like independent living centers, cross disability groups, intersectional groups where there are people with disabilities that make up the kind of population served by those groups, even if disability is in the focus, to ask questions about needs. And then there's no substitute for actually kind of trying things and seeing how they work. And it often means for us tagging along in a way where we don't know what the heck we're doing, but we're certainly observing folks who are really kind of testing out equipment, facilities, trails, access, technology, et cetera.
This is Riz. I'd like to add, from my personal experience and going to many different national parks and different centers, and most of them are not deaf, blind accessible. Yes, they have audio for blind people, or they have visual for someone who's a visual person, like captioning on the TVs, but they don't have anything that's someone who is deaf and blind or with a hearing impairment. Something that's tactile, or a map that has some kind of texture on it that can tell you where the trails are, or the water, where are those located? There's nothing like that for a deaf blind individual to use it, because the deaf individual can't use the audio part and the blind person can't see the captioning. So, and Braille is not very helpful. When it's word. We need something that's a little bit more extra for that access up for someone who has both deaf and blindness. And there, a lot of times what happens is they don't know what they need to do because they just have the audio and they have the captioning on TV. And so they're not sure how to meet those needs. They don't have enough exposure or working with individuals like that in the nature centers and how to interact with. It's a very small community, and I think that that's part of the reason why.
So what I would say is, in the Park Service, we actually are really trying to work hard toward providing those kinds of tactile experiences that you're describing, whether or not it is a tactile map that simply orients you to the visitor center that you're in, or it could be a tactile map that, is of the mountain range, or a tactile map that is of the, of the park itself, so you can feel where trails and rivers are. This is not to say that those are everywhere, but we do have many of them, and it is one of the things that we want to make available for that experience. In answer to the evaluation question, what I would say is, when we develop things like that, or when we develop accessibility, we do, like you were talking about, Stuart, we bring in people who, from the disability community, to help us frame what should this tactile model include. How can we make this meaningful? Can you tell the difference between this texture and that texture, et cetera? So we're fairly good at getting input up front. What we haven't been able to do really is that end user evaluation of, well, now that we've installed it, how well is this working, right? Because one of the issues we've got is, once it's installed, it could be there for 20, 30, 40, 50 years. So it's going to be a real bummer if we find out later that even after having done all this research, it doesn't effectively communicate what we're trying to communicate. So really, I would say our measurement for that is, are people who have that experience telling other people about the experience, right? How good of word of mouth are we getting within the disability community about, oh, I had this great experience at this park, you should go there. The other thing we have found is, in the true spirit of universal design, what you will find is the first people to use those tactiles and other things are children. I've seen all sorts of people who don't have disabilities also using it to enhance their experience. So that tells us, I think, that we're on the right track, particularly because we try to say our criteria for evaluating whether or not we're making good choices are the universal design principles. We want to say, okay, we could just meet whatever the minimum standard is. We want to do better than the minimum standard. How do we decide what better is, and what flexibility we have within the constraints of the environment or the historic setting, et cetera? We would use universal design as that framework, and apply those principles to decide, it's the difference between, well, can we have no ramp whatsoever, which is the best design choice? And if we can't, well, then we shouldn't default to the steepest ramp. How do we make a decision about, within our constraints, what is the most universally designed ramp we could have, that is most accessible to the most people, that falls in between no ramp at all and the ramp that meets the minimum standard?
This is Kristine. I think that Jeremy brought up something important when he mentioned that persons without disabilities are using these tools as well. Accessibility benefits everyone. It really does. When you look at the accommodations put in place during COVID, which is still ongoing, it benefited everyone. And it was a lot of accommodations that persons with disabilities have been pushing for pre-pandemic. So when you think about accessibility, it really does improve things for everyone.
This is Riz. Yeah, I'd like to add to Jeremy's comment. I completely agree with you on as far as universal design and making sure, trying to fit individuals within that environment. For example, Wilderness Inquiry Team, we review our curriculum for the day trips that we have, like environmental education, science activities, different things. We review all of those, and we make those accommodations to meet whether it's mobility, whether it's neurodivergent, whether it's a deaf or hard of hearing individual or a deaf blind person, low vision, all those different disabilities. We make sure that we accommodate for each of those, and we try to be creative. For example, tying knots. we try to figure out how can we do knot tying. I'm so sorry, she's frozen. How to teach someone with neurodivergence, or adding certain things on top of, animal head or something on the knots, so that they're able to feel that and be able to manipulate it easier and make it more visual. And, where do they start with the knot and how they end with the knot? And we try to be really creative on how to meet the needs of each individual person in all different kinds of ways.
We have a question from a participant asking if there are needs that clash with each other. So from your professional experience, what are some of the most common design challenges that come from clashing needs, and what are ways that we can overcome them?
I may not be able to give you any examples of how we overcome them. I can certainly give you some examples of the sorts of clashing needs that we find in the parks that we have. An example would be, for individuals who are blind, providing audio description. For example, audio description of an exhibit, audio description of a tactile, of a wayside or something like that. And what we might have is, in a visitor center, there are multiple places where you push a button and that button provides you audio description. But there's a conflict with that ambient noise and a person who has a hearing disability potentially, because now we've got this ambient distracting noise happening. Or it could be difficult for a person who has autism, because again, now we've created this ambient noise. Another one that I foresee happening is going to be, I think, as there is a greater and greater push toward us having changing tables for adults, as we try to retrofit changing tables for adults into existing bathrooms, well, we're now then changing the circulation paths, and we're changing how much room there is available in that bathroom. And that could come into direct conflict with, how much space we need for wheelchairs. So we run across this pretty frequently, that in trying to create an accommodation, or not an accommodation, in trying to create accessibility for one group, we have created a challenge for another group. Another great example is our ability to put to have exhibits that have the correct reach range and are at the correct height that you can approach, approach underneath with a forward approach rather than a side approach, and where that conflicts with protruding objects that could harm a person who's blind, because are they cane detectable? So it's, can we create cane detectable, these cane detectable forward approach exhibits or waysides that also create the enough room for a person with a wheelchair to roll under them. So we're having these discussions all the time in the National Park Service.
This is Stuart. I don't have any specific answers to any of those questions. I do want to reiterate that the idea of both facilities, accessibility, and access to programs and services has evolved over time, and it's nice to see that there are different needs being incorporated at the design stage, which is wonderful, and that it requires additional creativity and thought at the design stage, which we always push for as attorneys. We're not the designers. And so it is often very difficult to conceptualize. The only thing I would say is that it's good to have those discussions early on at the design stage, and to work with folks who are cognizant of the issues early on at the design stage. But we have seen a few of those issues come up in our, particularly with accessible restroom facilities. We've seen a lot of this come up around improvements and interference with the path of travel. It's not an exact science necessarily, even with standards and the regs, it's not an exact science necessarily, but it requires significant thought and creativity. And our push as advocates is always to make sure it happens at the planning and design stage. And I did want to address a question that was in the Q&A kind of around design and the question of like, what's the built environment, where there may be a kind of common refrain, and we actually don't get the common refrain as much from folks working in design in park systems, but we do see it in the public sometimes, that there's kind of, there's this destruction of the natural habitat and so on. And I saw the question, the point in the Q&A that like, there's a history that we as a country have really we've through whether it's colonization or other things have kind of destroyed that we've been building on the natural habitat. And I don't want to dive too deep into that, but I do think the idea that a lot of what we work with in parks is actually a built environment, whether it's a building or a restroom facility, or even something that involves how trails, even that are designed to preserve integrity of the natural environment. There still is building, and there still is plan and design that goes into it. And our push is really to incorporate the best practices and what's going on in terms of access to programs, services, et cetera, in the design, because there always is going to be building, renovation, alteration, et cetera, in park systems. That's just the nature of the beast. And so it is, we try and diffuse some of the discussion about there's destruction of the natural habitat, because there's always maintenance, there's always building, there's always renovation. There is a built environment, whether we think of parks that way or not.
Could you possibly, this might be a question for Stuart and Kristine, discuss a little bit the legal framework for access? Stuart, you had mentioned discussing some of the cases that DRA has litigated, and speak to some of the framework's gaps and some novel or creative interpretations of applicable laws.
I can start. This is Stuart. I can start with some frameworks that our cases have utilized, and I've mentioned. I've touched on some of them before, but we work with a few kind of core concepts that are kind of built into the law. One of them, as I mentioned earlier, is program accessibility, which is built into Title II of the ADA. Title II of the ADA applies to public entities, really kind of any public park system, state, local, municipal, or regional. They're all covered by Title II of the ADA. As I mentioned, Section 504 of the Rehab Act applies to entities receiving federal funding or federal agencies. Lots of state park systems, even local park systems, often receive some sort of federal funding. So they are covered by the program accessibility requirements of both of those federal statutes. And that's the kind of experience piece that I mentioned. When we litigate that under Title II and 504. There are defenses, as I mentioned. You can't ask for something under program accessibility that would fundamentally alter the nature of the program at issue. There's also, with Title II, there's a defense around an undue administrative or financial burden. And occasionally money comes into that, and some concerns about seeking funding and so on. There is also facilities access, and that really is new construction and alteration of park facilities. And those look just directly at the architectural requirements under the ADA. It is the Americans with Disabilities Act architectural guidelines, known as the ADAG. There also are, for federal entities, there's the Architectural Barriers Act. Jeremy, correct me if I'm wrong on this acronym, but I think that the guidelines are called AGODA. In terms of the Architectural Barriers Act. But those are specific requirements when you do new construction or alteration. And when I say alteration, I mean something that affects the usability of whatever benefit or experience is at issue. Oftentimes for us, that's the path of travel. How do you get there? And then also, how do you use it? Those trigger these standards, which are in place already, irrespective of whether the place is deemed readily accessible when viewed in its entirety. The new construction alteration requirements are mandatory. unless doing so is technically infeasible or there's some sort of practicality issue with it. So that applies to pretty much all park systems. As I said, they're different standards depending on which laws in play. There are also state standards. So if you're doing, for example, if you're in California, you need to apply the new construction alteration requirements of Title 24 of our building code. And one of the beauties of the ADA and Section 504 as well is they, as advocates say, they are a floor but not a ceiling. States and even municipal governments can require more. We have a link in our materials I provided to a case involving the Four Freedoms Park in New York City. And we actually used the New York City human rights law in addition to ADA and Section 504, because there is a bit of expansion of what's protected under the New York City human rights law that goes above and beyond the ADA and 504. One example of that is not related to parks, but just to kind of give you the sense of the scope, there are limitations under the ADA regulations about subway accessibility, how many subway stations in New York City have to be made accessible. We actually use the human rights law to say, well, that's fine under the ADA, but because there's no similar limit under the New York City human rights law, the whole system has to be made accessible. And we recently had an agreement to make 95% of subway stations accessible for people who need elevators or can't use stairs. So that's additional places to look in terms of people looking at, for advocates, ways to address facilities, whether it's the built environment that's been newly constructed or altered, but also program accessibility. I wanted to mention one more piece, and that is access to technology, whether it's kind of tactile or models or assistive technology, but also information technology. And most park systems that receive federal funding are covered by Section 508 of the Rehabilitation Act. That is a kind of a national a set of standards that apply to federal entities and entities that receive federal funding. And some folks who deal with web and app accessibility on this call may have heard about a debate where the Justice Department hasn't issued standards on accessible technology for websites or mobile applications. Well, if your entity is covered by Section 508, you don't have to worry about a lack of standards issue. And so that's something that's important for advocates to keep in mind. There's also the World Wide Web Accessibility Consortium, the WCAG, which is not something that's put into place by a particular law in the US, but is a set of existing standards to look at. And there's a case in the Ninth Circuit a few years ago, the Domino's Pizza case, which essentially says if the Justice Department hasn't acted yet, you can still look at standards in the community or in the industry to determine what meets the kind of very general thresholds of the ADA. So I would encourage people to look at those as well. In terms of innovations around these claims and how they've evolved, I don't have too many to point to other than, I think that the concept of accessible experiences has really helped in a lot of ways. And I look to what folks are doing. For example, we had the case involving the Golden Gate National Recreation Area that Jeremy's organization is working on. I wasn't even aware of the concept of tactile models, for example, when we were doing the litigation. It was through the kind of community outreach and working with the National Park Service that evolved. And one of the benefits of the Section 504 and the ADA, as I mentioned before, is the threshold for what should be accessible, whether it's through program accessibility or reasonable accommodation or modification for somebody who's got an individualized need. That threshold is supposed to evolve with technology. And there's a great case, I think it was the out of the Ninth Circuit, Enyart versus a state bar, that has good language about that, essentially that, it's not static and the level of access needs to improve with technology. And advocates have interpreted that not just to include technology on the industry side, but also technology assessing needs for access and what the community is pushing for in terms of the level of accessibility and types of accessibility required. So I would certainly encourage people to think of that evolution as being consistent with the law.
This is Kristine. I'm not sure I have too much to add on this. Most of my work and experience is with the CRPD and not in domestic laws of various countries. So I'm going to leave that answer to Stuart.
So I would say we're in a pretty unique position in the National Park Service because, so number one, as a federal entity who is covered under the Architectural Barriers Act, we do in fact have outdoor developed area standards that apply to us. Which would apply only to federal entities and generally not to state entities unless they choose, state or local entities unless they choose to adopt them. So we do actually have standards that say, here's how you make a trail accessible, here's how you make a dock accessible, here's how you make fishing accessible, etc. I would also say that we are very rarely, if ever, allowed to use administrative and cost burden as a reason for us to not provide access or to not follow the law because we're the federal government. So I think the way that I look at it is, along the lines of what you were saying, Stuart. If I were to take the chain for us, it would be, so we have to make sure that our facilities are accessible. Now, and certainly if we're building something new, we've got to have it be built to code. If we are rehabilitating or altering something existing, we need to be bringing it up to code. In the case of our outdoor areas, whether it's camping, it's hiking, etc., a lot of those structures are very old, and we don't do a lot of anything but just routine maintenance. It is very, very rare that we build a new trail, very rare that we build a new campground. It is also very rare that we do significant rehabilitation to any of them. So while we might be able to argue, well, I don't actually need under ABAS to bring this up to code, well, that's where I would say Section 504 kicks in. And Section 504 would say, well, you might not under the ABA be required to make this accessible, but you still have to make all of your programs, services, and activities accessible. So that gets back to what you were talking about, Stuart, with the experiences, is like, people come here to hike. What is it that you are doing in order to make sure that they have access to hiking, whether it's on this trail or elsewhere, right? Another example I would give is layer Section 508 on top of that. So you take a visitor center that we have to make sure is accessible. So we then have to say, from a facilities perspective, we have to say, is this visitor center accessible? From a program perspective, we have to say, even if you can get into the building and navigate the building, what is the reason you're going into this building? Well, it might be to shop, it might be to use the bathroom, it might be to learn about the park, we might have a visitor center with a museum. Then all of that is covered under what are the opportunities from which you can benefit. So now we're saying, all right, that's all covered under 504 and program access. Can you get into the building? Can you do what the intent of the use of that building is once you're in there? And let's say we do have a museum, or we do have a film that we're showing to orient you to the park. All of a sudden 508 is coming into play, because now we have to make sure that we are captioning the videos, that we're providing audio description for the videos. We have many kiosks that are digital interactives now. So 508 is being layered on top of that. Plus, if you show up and none of those things work for you, you still have the right to say, I need this modification in order to allow me to benefit from this experience. So we have all of those at play. And as a federal entity, we don't get to say, well, that sounds too expensive or too complicated for us. Sorry. We try to get ahead of it as much as possible by, again, already having tactile map, already having audio description, already having captions. But you absolutely have the right to say, I'm going to be there and I need to have an ASL interpreter. So captions aren't going to work for me. So we've got all of those at play at once under ABA 504 and 508.
And just, Jeremy, you were right to say ABAS. I was looking for the acronym for the ABA's architectural standards. Thank you for that correction.
There is another question from a participant asking if Risk could possibly give some examples of places in the outdoor and indoor environment that are inaccessible, and to you personally, and how you would suggest updating them, which I think is sort of a good response to what Jeremy and Stuart have said about their actions or their organization's actions.
Sure, absolutely. For example, adding the tactile options, whether it's like animals in different groups and you're having to feel the shape of a bird or a beaver, different animals like that, giving a map that you're able to have tactile information from that. There was one place that had this large map, it was huge, where the campgrounds were, where the camping areas were in the water, like the river and the lake, and then the hiking paths and where you could park and bathrooms. It was right in the middle of the center, the visitor center itself, and you could stand around and you could feel it, and it had tactile information on that. So that was amazing. So it's really all I can think of right now. I could probably go on and on and on forever on that, but those are a few examples.
Thank you. Before we move into discussing, there are several questions from audience members about tensions between conservation organizations and disability rights advocacy groups. But before we go into that, we have one more question sort of about the approach to accessibility. One participant has asked that they're encouraged to have heard multiple mentions of the need to ensure that reservation systems are accessible, but if you could speak to more about what that means. So if there is a consideration about reservation systems, if a person has a need to make a reservation and they're unable to meet that reservation because of an inability to show up for that particular day, is there some flexibility, or is there inadequate flexibility in the reservation system for people with those kinds of disabilities who may never be able to visit the park?
So I can say that at the federal level, most of the federal agencies use what's called recreation.gov, which means individual parks, individual refuges, individual national forests are allowing you to make reservations for, I'm just going to generally use, like, say, campsites. There's more things to reserve than campsites, but that's the easiest example for me to give. We have many layers that we have to consider. And I am not at all saying that we are doing this correctly. I am merely saying that we are aware of some of the challenges that we have. So let's just say we have met the 508 requirements, and that it's accessible to a screen reader, or it's accessible to other assistive technology that the baseline website is, right? So we still experience the challenge of the fact that very often we'll say, hey, reservations for this campground open up at 7 a.m. 6 months in advance of when you can make the reservation. Well, that's automatically discriminatory against anybody who can't be at a computer at 7 a.m., for example, right? That automatically means you're probably not going to get a campsite. Number two, it's like getting tickets to the Taylor Swift concert. We can literally have a campground fill up in 15 minutes, which means if you have some form of technology that creates a delay in your ability to process the information, in the ability to respond to the information, and the ability to type your answer or whatever it is, you automatically, again, you might just lose out simply because you're 30 to 45 seconds slower than everyone else, right? Not to mention if you don't have access to the internet in the first place. These are all structural problems that we recognize. Then you take into account the fact that, there may be in a 25 to 30 site campground, there may be only 1 or 2 sites that is designated as accessible. So you're not even competing for the full pool of 30 to 25 sites. You're competing for a pool of 2 sites. And we don't have a consistent policy as to whether we hold those sites back, whether or not we make anyone who wants to reserve those sites provide some proof that they are an individual who needs that accessible site. Because then we start getting into, well, how much information about your disability can we require you to provide on this website? How do we mitigate that for first come, first serve campgrounds? Meaning, we've got 20 sites, there are 2 accessible, and 20 people without disabilities, 20 people showed up without disabilities. And because of your disability, it's difficult for you to get there in a timely manner in order to claim a site for first come, first serve. Do we have policies for that? I am not at all saying we have answers to these challenges. I am, however, saying we are aware of these challenges and how these reservation systems can cause problems in the same way we're now experiencing, where sometimes you need to get a time ticket reservation just to go to the park itself, and you have to have that done online. And we recently had an experience where somebody who needed to have a van accessible space did not get into the queue for the cars that needed to come in on a particular day that they were going to be visiting this park. And how do we navigate that? Is there somewhere where we have to build in that may be a reasonable modification we've got to make, where we say we have to allow this person in, even though we are over our number of reservations? These are all emerging questions for us that we have to think about.
This is Stuart, just to follow up on that. And I like how Jeremy used reasonable modification in the answer. We've mostly dealt with reservations in the context of information about reservations, about the reservation program, making sure that particularly if there's online systems for reservations, those are accessible, the kind of stuff that Jeremy mentioned in the initial part of the discussion. But that doesn't mean that this could not be a question that presents a reasonable modification. And it's the kind of thing that advocates could raise as a reasonable modification. And just thinking out loud, it could be that there's a way that there's a certain, if there's particularly if there are enough folks impacted by this problem with not even having access to reservation systems or not being able to utilize them for whatever reason, that there could be some form of same-day access or something along those lines, and the same balancing would occur. And I love the national parks systems acknowledgement that mostly cost-related burdens don't apply. But there could be some other balancing that occurs, under a fundamental alteration. And with smaller park systems, particularly those covered by Title II and state law, there could be some cost analysis as well. But I think that's where the discussion would be housed: is it a reasonable modification or not? And I would encourage folks to use creativity in terms of thinking of solutions that might be considered a reasonable modification that wouldn't, fundamentally alter programs at issue.
This is Riz. I'd like to add to that. The survey on the website, for example, the very beginning of this discussion, when we're talking about the word accessibility, if the website, you go on to reserve a campsite and they have all these different, check marks that you want included. So if you have accessibility checked, but behind that, what does that mean? I don't even know what that means. So I show up at the campground and I go, oh, it's not accessible for me with someone who is in a wheelchair or someone who accessible to the fire pit. There's no accessibility to the bathroom. Maybe it means accessibility for mobility only. And so some of that needs to be clarified on the website too, and developing options within that. What does that really mean as far as accessible? That can be easily misunderstood sometimes.
So there are several questions from participants talking about these tensions between conservation and accessibility. We have someone that has raised the issue of colonization in the country has created nonstop building and modification. And how do you address those who challenge modifications that change the natural environment too much when used as a coded way to oppose accessibility for those with disability? We also have a participant that has asked, has the increased usage of other power-driven mobility devices made it less or more complicated for persons with mobility issues to access park areas that have been designated as non-motorized? Everyone's sort of touched on this a little bit, and I think it was Jeremy that talked about the fact that essentially, perhaps Stuart, that there's not really wilderness. All of this is touched by man in his built environment anyways. But could you all speak to those sort of tensions between preservation and access?
Sure. I think kicking it off, this is Kristine, and removing the word tension, because that's putting persons with disabilities and their organizations pitted against conservationists. And persons with disabilities want to preserve the natural habitat. We're not wanting to change everything and ruin it, but the word tension implies that we might be. We really do have the same goal of enjoying these spaces, and it's about accessibility and how to, merge our goals and what we want and not frame it as a contentious point.
Mr. Stewart, I like that approach, and we are often reminded of that by community advocates as well, who are often, if there was much more dialogue, folks, members of the public who are kind of expressing these kind of conservation views would see a lot of parallels and common ground with folks in the community groups we work with. I don't have an answer. Jeremy asked a great question during our prep session about some of these issues. I do not have a specific answer to those. I do think it's worth considering the reasonable modification and analysis and where the line is. I couldn't tell you. There's a lot of balancing out there and looking at other ways to make those kinds of experiences accessible. I did want to, and I didn't put this in the material, I didn't think about it until later, but there's a case in the Ninth Circuit, Bauman versus Walt Disney, that discusses where something isn't covered necessarily by existing standards around, either personalized aids or vehicles or any of the kind of specifics. That case involves segways at one of the Disney parks, and I don't bring up the case to say that gives me an answer either way, but I think it's worth kind of analogizing to other systems. The only thing I would point out, and this makes the question more difficult, is in some cases there are competing federal statutes at issue or federal guidelines, so it just complicates things a bit. And we often in our work, we look to kind of, that navigate that narrow path between, so that there isn't actually competition between what we're seeking for, what we're seeking under the ADA and Section 504 and other federal guidelines. But it's just something that requires an incredible amount of thought and discussion and creativity. And I would encourage folks to look at examples outside of the parks context where something, some form of access is being brought in that may not be prescribed or enumerated in specific standards or the regs. But to that specific question on the motorized vehicles, I don't have an answer today.
I will respond by saying I would divide this topic into two sections, right? We do actually have this concept of federally designated wilderness, capital W, which has a meaning in terms of like what it's legally, the way in which it is legally protected, different from just us saying, oh, wilderness, which is maybe not federally designated wilderness. So there's a capital W, and I will set that aside for now. And then there is everything that is not capital W wilderness. So my answer to the first thing about balancing preservation versus accessibility is I generally expand that into a conversation about just good design. Good design is accessible, it's sustainable, it reduces your amount of maintenance. And in fact, in a lot of cases, some of the design that creates accessibility is better for preservation. When you're putting in boardwalks and you're doing other things that keeps people from wandering off into places you don't want them wandering off to, that's a win for everyone. So I'm trying to dispel that myth that they conflict with each other. I don't think good design conflicts with the goal of preservation at all. But again, to me, that is also in front country where we're admitting we have a built environment here. The built environment exists. We have already modified things. It is just how much we have chosen to modify them that matters. Once you get into wilderness, capital W wilderness, the modifications that have been made are fairly minimal. And the intended uses are very different. And I will say that, once we get into designated wilderness, our own staff in the Park Service cannot bring motorized things in there without getting a waiver, without getting permission. We can't even bring a wheelbarrow into these wilderness areas according to our rules. So that is a very different animal. When it comes to other power-driven mobility devices, I would say we look at them in the way that, Stuart, you're talking about as reasonable modifications, or more precisely, to us, that's an individual analysis, because it depends on what device you want to use and where you want to use it. And I think the onus is on us to be able to do that analysis, because I would say there are some devices that depending on where you're asking to use it, we might say, yeah, absolutely, we should allow that other power-driven mobility device to be in that area of the park. You might ask to use it somewhere else that I don't know that is something that we can do without it creating some threat to the environment or requiring some fundamental alteration. And I think that's one of the challenges we have is it's doing that individual analysis every time. And we can't simply say, yes, this device is allowed all the time and this device is not allowed all the time. It's going to have to be a case-by-case decision. The other challenge that we run across is that doing that analysis implies somebody has contacted us ahead of time and said, hey, is it okay if I bring my such and such? And it isn't that they've just shown up with that device and now a ranger has seen them and we have to make a decision on the spot. And the likelihood of them understanding the criteria for what you look at for whether or not we should permit this device, it begins to get complicated. So we're having a lot of discussion in the Park Service about adaptive devices and these definitions of is it solely used for people with disabilities, or is it a device that, can be used by anyone? And then once you get that into a wilderness context, it gets really complicated of saying, can we even allow this in wilderness as a modification? Because it is a motorized device and the law says no, we don't allow motorized devices, right? To the point that we have debates about they have these particular kinds of backpacks that are attached to a wheel for people who have back problems. And can we even go as far as to allow those conveyances into wilderness? I'm not saying I have answers to any of that, but what I'm saying is that there is a lot going on when it comes to other power-driven mobility devices. Their power to expand accessibility definitely in front country and in our more popular environments.
We have about 10 minutes left to the discussion. So I was hoping that everyone could speak to the future directions they see this topic going in. So maybe emerging trends in technologies that have potential to further enhance access, any ongoing research or pilot projects, or law and policy changes on the horizon that might improve accessibility and inclusion.
I can start. Oh, so I see Riz has a hand up, so I will wait.
Yes, this is Riz. For sure, if we saw our perfect dream world with perfect access would be ideal, but I think that's pretty far off in the future. I think what we're hoping is to have more research projects specifically related to how to improve those areas and environments for accessibility, like trail access, for example, that had signage with different information and location information and historical information about the park, to add some kind of information for people with accessibilities, maybe having a sign language video, for example, or someone who has difficulty with understanding English reading, they could see it in ASL. Also, maybe having ropes on specific trails so someone could follow that rope as a guide and use that as a guide as they walk down the trail, to have one specific hand-held rope guide. And changing and updating the laws, of course, to keep improving accessibility, because many of those have been left unchanged for 25, some of them 23 years, for accessibility with everything related to employment, within the natural environments and in the public themselves, and public accessibility. So of course, I'd love to see improvement in those areas. And there are a lot of things that we need to change.
This is Stuart. I can share, and some of our evolution in the work we're doing and kind of where we're heading is a little bit less focused on technology. I'm very intrigued by a lot of the technology we're seeing in the park systems, particularly with like the tactile models and accessible guide information and tours, as well as stuff that can be done online and via apps. But internally, we've had to really focus on some of the kind of complaints we've received doing our outreach, and we've realized traditionally we've kind of ignored the kind of urban and suburban park systems in a way that maybe hasn't, particularly for folks who can't get to as many national parks, or post-pandemic really have, they've been at home and kind of need some access to recreation and parks nearby. So we've started to focus on suburban and urban park systems. Much of our work in that area used to be around things like pedestrian routes, and there's still plenty of work to be done. You step outside, the problems with pedestrian routes everywhere. So we still do that kind of work. But looking at more kind of park facilities, playgrounds, things like that, that impact folks who may not, for a variety of reasons, should have access to all the park systems, but maybe due to economic or other reasons, may be kind of limited in where they go. And there's a lot of work to do, and we don't necessarily have a handle on how we're going to start. But that's an area we're looking at more of the kind of local park structure. There's some case law on it that we've got to, some of those program access limitations apply to these systems as well. So we have to look at what legal angles we're going to take. But that's been a recent point of focus for us.
This is Kristine. While I was preparing for this webinar, I saw something cool that Greece has recently done. They are making their beaches accessible by adding power chairs on ramps that persons with mobility issues can get into the chair themselves. It goes down the ramp and takes them to the water so they can have that benefit, spending time in the water. They can do it themselves. They don't have to rely on a friend or a family member to be able to do that. So those type of innovative things are really cool. It's the funding that governments need to be able to put that funding behind it to say, yes, this is a right that persons with disabilities deserve to be in these spaces and have a right to be in these spaces. And along those lines, it's the attitudinal barriers that changing minds about what persons with disabilities can and can't do and not defining them in a really siloed and set way, and making sure that, yes, persons with disabilities do belong in nature, that they can do it. They can do it. And it's really an attitudinal barrier as much as a physical barrier in a lot of times.
That's actually great for a segue to what I was going to say, because I saw that there was a question about employment and people with disabilities. So what I would say, exactly what you're talking about, which is sort of like a culture change, a way of viewing the world change. One of the things that we've been talking about in the Park Service is, every change that we make to make a park more accessible for visitors with disabilities is going to make it more accessible to employees with disabilities. Every change that we make to make it more accessible to employees with disabilities is going to make it more accessible to visitors. And in this era of diversity, equity, inclusion, and accessibility, one of the things that we know is people with disabilities are not seeing people with disabilities in our workforce. That automatically makes it a less welcoming environment. Furthermore, if we have more people with disabilities in our workforce, well, that's going to create a culture where, my colleagues understand disability better, which means my colleagues now can serve our visitors with disabilities better, right? And then, as Kristine, you were saying about this idea of people with disabilities belong in nature. So if you're seeing our employees with disabilities, that tells you, yeah, you belong here. The other way that we want to convey that is, there was a second question in the chat about providing better information related to accessibility. I would say for us, that is a huge focus of what we want to do, is not assume that we're going to tell you what is or is not accessible. Tell you what the conditions are on the ground, and then you can make that decision. We have many circumstances in which, as I was referring to before, we might have a campground that has only 2 accessible designated sites, but every single picnic table is an accessible picnic table because what that park decided to do was, hey, when we order our next round of picnic tables, just make them all accessible. So what that means is we might have 6 or 7 or 8 campsites that many people with disabilities could use, but we're not telling them about the conditions of that campsite to make them go, oh, well, I actually could stay at that site. I've seen a picture of it. That would work just fine for me. We're, along the beach access thing, we have probably 6 parks around the system that have beach wheelchairs that you can reserve or loan out. That could really you could make a decision about your vacation and travel destination once you decide, oh, I could take my whole family there if they have, that beach wheelchair. But what we're not doing a great job is letting people know where those opportunities are. Where do we already have tactile models and tactile maps that might change your opinion of where you go? Do we have visitor use guides that could help a person with a disability plan a trip to Yosemite so they would know, oh, it looks like the bathroom at this overlook is probably not going to work for me. But based on this information, if I go to the one 2 miles down the road, that one will work for me. Well, that's going to change the tenor of your trip completely, because where they have the resources that are going to meet your needs, and you can plan ahead for that. So I think that for us is that future trend is, how do we leverage apps? How do we leverage websites? How do we make it so that you come with the information you need to make your own decisions about how you access the experience that you want to access?
That unfortunately is our time for this afternoon. I would like to thank everyone for joining us for this free webinar and express our gratitude to this esteemed group of panelists. You're all doing such critical work, and we thank you for taking the time out of your schedule to share your experiences with us. The section for Civil Rights and Social Justice provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps you in your work. And again, if you can, please consider joining and becoming an active member of the ABA. You can do so at americanbar.org/CRSJ. Thank you again, and best of luck in your work, and stay safe, everybody.